everybody. I'm going to go ahead and introduce him. Before I get to that, though, I want to first thank John Packer, the Director of Human Rights Research and Education Center, as well as Viviana Fernandez, the Assistant Director, and Caroline Fauché, around somewhere, doing something useful, our communications agent for supporting the event and for hosting it. So this is the second in the, my name is Meredith Toretta. I'm the Gordon Henderson Chair in Human Rights here at the Center. And this year I'm organizing a Refugee History Speakers Series. So this is the second event in the Gordon Henderson Refugee History Speakers Series. And before I introduce Umut, I'll just mention we have a couple of other events coming up. The third speaker in the series will be here on the 11th of November. That is Remembrance Day. That's a Friday. Her name is Darcy Fontaine. She is a historian, and she'll be presenting a talk entitled Refugees, Sovereignty, and Humanitarian Anxiety, Regroupment Camps, and the Limits of Universal Rights in the Algerian War of Independence. So she is a historian of France, but she works in Algeria. She will be presenting in English, but she will take questions in French. She's prepared to do that. On the 28th of November at 1:30 p.m., we have Alexis Choya from the University of Toronto, who will be speaking in French on Boko Haram, médias et discours sur la sécurité au Cameroun. So it's a more contemporary question of displacement in the Sahelian region. Populations displaced by Boko Haram, but he will integrate media depictions and historical perspective into that a bit as well. The same day, the 28th of November, the Gordon Henderson Refugee History Speaker Series is co-sponsoring an event that evening, which is the International Commission of Jurists of Canada is having its annual Tarnopolsky Award event. So that's scheduled to take place on the 28th at 6 p.m. on the 12th floor of Desmarais. And we've just decided recently to have the format be an armchair conversation between the award winner Jennifer Bond of our own law school here and James Hathaway, who is the James E. and Sarah A. Deegan Professor of Law and Director of the Program in Refugee and Asylum Law at the University of Michigan. So this event is co-sponsored, as I said, as part of the Refugee History Speakers Series. So now to get to Professor ÖZSU. Professor ÖZSU is an assistant professor of law and legal studies at Carleton University. So it wasn't too hard to get him over here. His research interests lie mainly in public international law, the history and theory of international law, law and development, international human rights law, and international refugee law. His first book, Formalizing Displacement, International Law and Population Transfers, was published by Oxford University Press in 2015. He's currently at work on the second book, this one concerning the legal dimensions of the post-Second World War wave of decolonization. And the working title of that one is Completing Humanity, the International Law of Decolonization. So I'm very much looking forward to that. Professor ÖZSU has served as a junior faculty member at Harvard Law School's Institute for Global Law and Policy. He was a junior fellow at the University of Toronto Center for Criminology and Sociolegal Studies. He's an elected member of the Coordinating Committee of the European Society of International Law's International Legal Theory Interest Group. He sits on the board of advisory editors of the London Review of International Law. Professor ÖZSU taught previously at the University of Manitoba, where he received the 2016 Award for Outstanding Contributions to Scholarship and Research. I bet they were sad to see you go, which is the highest research award for junior faculty members at the University of Manitoba. His publications are numerous. When I take him to lunch, I'm going to ask him just how it is that you are so prolific. I hope you can give me your secret. In the form of books, co-edited books, book chapters, articles, and opinion pieces in the press. He is published in the European Yearbook of International and Economic Law, in Humanity, an International Journal of Human Rights, which is where I first came across his work, in the London Review of International Law, the European Journal of International Law, the Harvard International Law Journal Online, the Leiden Journal of International Law, and many, many others, which I will not mention or I would take up all of his speaking time. So without further ado, I introduce Professor
Thank you very much, Meredith. That was way, way too generous, far too generous. Meredith, of course, very kindly omitted to mention that I was late this morning, for which I truly apologize. I was actually unable to find parking until the last minute, so I was just basically circling around for about 20 minutes. Parking is not one of the things that appears on my CV, unfortunately. So today, what I want to do is, thankfully we have an ample amount of time, and what I'd like to do is take about 35 odd minutes or so, ideally, to just talk about a paper that I have that's very much a work in progress. So thank you so much to Meredith and to the Center as a whole for having me here. I'm truly very, very thrilled to be here, not least because it provides me with the opportunity, me and my co-author, just more about that in a second, with the opportunity to get some substantive feedback at what is a relatively early stage in the development of this particular manuscript. Oh, I think I should turn this on, actually. Oh, it's on. Okay, perfect. So as I mentioned, this is very much a work in progress. It builds on the work that I've done in the past relating to the history of the international law population transfer. It is a work in progress that I'm working on with Itamar Mon, a senior lecturer of law at the University of Haifa. It also builds on work that Itamar has done in the past on refugee protection, on minority rights, on the history of international law, and so on and so forth. So in addition to the book that Meredith very kindly pointed out, Itamar has a book coming out with Cambridge University Press called Humanity at Sea, very timely, and very, very ambitious book as well. And this paper is basically an attempt to sort of riff off of some of the topics and themes that pop up in my book, in his book, in other writings that we've produced, with a view to talking about some contemporary issues that are particularly that are of particular salience in the contemporary juncture. So that's just basically a sort of lay of the land. What I'd like to do is basically just sort of sketch, outline the central elements, the key constituent elements of this paper. As is clear from the abstract, it has to do with population transfer. It has to do with the history of population transfer under international law. And what I'd like to do is basically provide a sort of précis of the argument that I ran in my book, my earlier book, having to do with the interwar exchange of minorities between Greece and Turkey in the 1920s and 30s. This is one of the, arguably the most important enterprise of its nature, certainly in scope and sophistication, logistical or technical sophistication. It's an internationally coordinated compulsory transfer. So I'd like to talk about that. After briefly talking about that, I'll move on to talk about two contemporary modes of what I, and Itamar at least, characterize as population transfer. That's going to be a contentious point. The one is so-called climate change refugees, forced migration induced by climate change. And the other is basically the readmission agreements, the so-called readmission agreements between Turkey on the one hand and the European Union on the other. So the latest readmission agreement, the most controversial, was concluded on March 18th of this year. And it's currently in a state of legal and political limbo. So I'd like to say a few things about that. And the general argument that I'll be running, that Itamar and I will be running, is basically a sort of structural point. Indeed, it's a structuralist point. It's about the way in which notions of population transfer get produced, get consumed, get distributed, and circulate as legal techniques, indeed possibly as legal fictions, as it were, as conceptual categories from one jurisdiction to another, and mutate, get transformed in the process. So both Itamar and I are at root socio-legal scholars. We attend, of course, the doctrinal architecture of law, but we're interested in the way in which law functions socially, socially understood in a capacious sense, of course, economic, political, indeed even cultural, and so on. Okay, so international law is typically regarded as a source of protection for displaced persons, something of a palliative, if not necessarily a panacea, to the dispossession and displacement that characterizes so much of modern life. Yet, in addition to performing this work, which is indeed important work, International law also formalizes, coordinates, and legitimates countless forms of forced migration. Indeed, international law does not merely sift through the legal implications of individual or group movements that have already commenced, extending protection to asylum seekers who satisfy the basic conditions set out in the 1951 Refugee Convention and a host of attendant domestic and international instruments. It also, in addition to that, generates and provides justificatory rationales for many such movements. Its rules and principles providing the normative architecture for agreements that directly or indirectly give rise to large-scale migration. What's more, the structural links between the various mechanisms and procedures whereby international law facilitates a response to mass displacement generally remain poorly understood. A variety of calls have been issued in recent years to rethink relations between different forms of social, legal, and economic exclusion and expulsion. A good example is social theorist Saskia Sassen's latest book, Expulsions, which considers forced migration, including but not limited to the kind that stems from land grabbing, the large-scale acquisition of land and land resources in developing countries by wealthy states and corporate investors, typically for the purpose of engaging in agribusiness and securing reliable sources of food and biofuel production, in tandem with the socioeconomic inequality spawned by the neoliberal capitalism of the past 40 years. Even so, our understanding of the relations between different forms of displacement and international law's engagement with them is still very muddy, leading many, though certainly not all, scholars and commentators to broach contemporary developments as conceptually discrete and historically unprecedented phenomena, capable of being isolated and subjected to independent analysis with relative ease. So the paper upon which this talk is based, the paper that Itamar and I are working up, seeks to remedy some of these deficiencies, though admittedly in a fairly modest way. It does so by tracing some of the key connections between different forms of population transfer, the legally regulated movement of groups from one location to another. I note in passing that the expression population transfer has frequently served as a kind of euphemism for what we now have come to call ethnic cleansing, or worse yet, genocide. Nevertheless, it's typically understood and employed as a distinct category of international legal analysis, one with a distinct history and accompanying conceptual apparatus. So I begin by discussing the treaty that formalized the compulsory exchange of minorities between Greece and Turkey during the interwar period, one of the most significant and most controversial precedents, so-called precedents, in the history of legally mediated and internationally coordinated population transfer. I then consider the role of international law in two contemporary and also future forms of displacement: the organized resettlement of large numbers of climate refugees, so-called climate refugees, and the European Union's reaction to irregular migration, so-called irregular migration, with readmission agreements. My core claim is that far from being simply a reaction to en masse migration, contemporary international law generates and lends credence to collective displacement through means that are in some respects similar to those that are characteristic of earlier periods. Okay, so kind of a précis of the Greek-Turkish population exchange, 1922 to 1934, roughly. A crucial episode with wide-ranging implications whose international legal dimensions remain under-scrutinized, the 1922-34 exchange of minorities between Greece and Turkey was the principal galvanizing force behind the cultivation of population transfer as a distinct mode of legally formalized nation building in the early 20th century. To be sure, experience had been gained already with ostensibly voluntary treaty-based transfers in Anatolia and the Balkans and elsewhere. Resettlement programs remained ubiquitous, from deportations and land reforms in Russia to the continued expulsion and resettlement of indigenous peoples in Africa, the Americas, and elsewhere, Canada. But no legally formalized and institutionally reinforced international compulsory exchange had ever been undertaken on the level envisioned here. As the first legally structured compulsory endeavor of its scale and sophistication, the sheer ambition of the Greek-Turkish exchange was staggering. Over 1 million Greeks, or those identified as such, sometimes wrongly, were uprooted from Asia Minor and Eastern Thrace immediately before and during the formal exchange, which began in 1923 and continued for years to come. And something in the vicinity of 350,000 Muslims, that's the usual estimate at least, or those so classified, were expelled from Greece's mainland and islands over the same stretch of time. Aside from a few exceptions, most notably for Greeks established in Istanbul and Muslims established in Western Thrace, as you can imagine, established became a bone of contention for both parties, the exchange of minorities was total, comprehensive, and by design, fundamentally irreversible. Supported by Athens and by Ankara, and implemented largely by the League of Nations, the Greek-Turkish population exchange showcased the new pragmatism of the post-First World War international order, an increased willingness on the part of lawyers and policymakers alike to adapt legal doctrine to local dynamics and conditions, bringing greater, more sophisticated institutional resources to bear on crafting functionally suitable solutions to pressing problems. The chief aim here was not to organize plebiscites or install protective mechanisms for under-resourced or underrepresented minorities, both important if unevenly applied techniques in the Allied powers' project of managing imperial disintegration in Europe after 1919, nor was it to restructure all facets of a given economy and society in order to generate an entirely new legal system. This had often been the case with colonialism in Asia, Africa, and elsewhere, and it would certainly characterize a good deal of the League's mandate system, the regime of internationally supervised foreign administration through which certain territories detached from the defeated German and Ottoman empires were governed during the interwar period. Instead, the aim of the Greek-Turkish population exchange was to reshape the demographic composition of the two states in question, aligning ethnos, ethno-nationalist collective identity, with demos, civic nationalism, as tightly as possible, and with the help of a mechanism that was tailored specifically to the region at hand. If Greece and Turkey were to be refashioned by way of a compulsory exchange, a mechanism whose status under international law, the international law of the time, was imprecise, but with which many lawyers were nevertheless willing to work, this was due in no small part to the semi-peripheral character of Greece and Turkey, which both permitted and demanded reliance on a distinct procedure. Okay. The formal exchange that was prepared at the 1922-1923 Conference of Lausanne, at which a final post-First World War peace settlement with Turkey was concluded, followed the expulsion of large numbers of Greeks and others from Asia Minor and Eastern Thrace in late 1922. It has therefore sometimes been presented as an ex post ratification or endorsement of an already existing reality. Mark Mizauer, for example, is inclined to present it that way. This ignores, I argue, the fact that the formal exchange called for a variety of fresh movements, nearly all 350,000 Muslims, and roughly 200,000 of the concerned Greeks. It also misses the crucial point that the formal procedure lent legal authority to a set of movements that redistributed land, people, and capital across enormous swaths of territory, establishing a comprehensive legal regime to manage relief, resettlement, and compensation efforts in the process. More than 2 months of tough negotiations at Lausanne were needed before Turkey and the Allied powers were able to agree on the terms of the exchange, and all parties invested heavily in the talks. This was an exercise both in producing new facts on the ground and in juridifying the dispossession, displacement, and capital accumulation that had already taken place. Now, the long-term consequences of the exchange were enormous. The demographic composition and sociopolitical identity of each country was changed forever. In Greece's case, the total number of refugees amounted to approximately a fifth of the country's entire population at the time. Further, the endeavor provided a rough and ready precedent that would be invoked in a range of different contexts during the decades that followed. Regardless of its regional provenance, its regional specificity, legally mediated population transfer and related forms of demographic engineering traveled to other regions before long, experiencing something of a successive globalization in the process. The late 1930s and early 1940s, by which time Stalin had begun resorting to internal deportations in an effort to consolidate his nationalities policy, but most of those displaced by First World War-related hostilities had either been resettled or repatriated, Nazi diplomats concluded numerous transfer treaties with the Soviet Union and other Eastern European states in the name of the Reich's supposedly protective right over its ethnic kin. So ethnic Germans in Latvia or Romania, Estonia or Croatia were to be given the right to opt for German citizenship and thereby submit to an ostensibly voluntary transfer to German territory. Immediately after the Second World War, the Allied powers made heavy use of compulsory transfer as a means of removing ethnic Germans from Central and Eastern Europe, a process that overlapped with that of resettling displaced persons in occupied Germany, possibly the first true site of application for the budding post-war refugee rights regime. The partition of British India in 1947, generating disputes about the management of population movements in addition to quandaries of state succession, was followed in 1948 by the devastating exodus of Palestinian Arabs, and in 1972 by the expulsion of South Asians from Idi Amin's Uganda. This in turn was trailed by forced migration in Cyprus in 1974 and 1975, and throughout the former Yugoslavia, particularly Bosnia during the 1990s. The legal architecture of every such movement, and there were others of course, was different. Some took the form of unilateral transfers or bilateral exchanges inaugurated by law, while others were uncoordinated movements subject to after-the-fact ratification. In certain cases, international law organized the movement from the outset. Others, it completed a task that was already underway. Yet, the logic of legally formalized population transfer and the nation-building techniques with which it was accompanied and which were frequently rolled into broader development agendas circulated with remarkable consistency. In most cases, from the 1945 Potsdam Conference to the negotiations leading up to the 1995 Dayton Peace Agreement, the Greek-Turkish population exchange was cited as a key precedent. Once considered only in respect to the so-called Near East, a region regarded as falling short of Western standards of civilization and subject to manipulation by imperialist powers, population transfer had now entered into the general lexicon of statecraft, appropriated by many of the same states that had originally voiced discomfort at its precedential consequences. So that's a brief outline of the kind of argument that I run in that first book of mine. From there, let's just move on to climate change refugees, forced migration due to climate change. Now, we've all heard of countless situations in which sustained and irreversible climate change is expected to cause permanent, large-scale human migration. In most cases, the anticipated forced migration is expected to result from rising sea levels, which will make life impossible or at least exceedingly challenging for inhabitants of low-lying coastal areas and even entire islands. In response to growing awareness of the probability of this kind of devastating, though slow onset environmental change, a significant number of states, chiefly in the Pacific, but also in Africa and elsewhere, have begun to prepare national, domestic guidelines for planned relocations due to increasingly extreme climatic shifts. In addition, several projects have been launched by states and international and non-governmental organizations to formulate multilateral standards for designing and implementing cross-border movements. The impending phenomenon of climate refugees has become a focal point for governments and ever larger numbers of citizens from Tuvalu and Kiribati to Gambia and Mauritania. A good example of this growing interest is provided by the Nansen Initiative on Disaster-Induced Cross-Border Displacement. It's kind of a tongue twister. Named, interestingly enough, after Fridtjof Nansen, the Norwegian diplomat and first League of Nations High Commissioner for Refugees and one of the principal organizers of the Greek-Turkish population exchange. Launched in October 2012 and brought to a formal conclusion 3 years later, the Nansen Initiative, funded largely by Norway and Switzerland, and involving the Office of the United Nations High Commissioner for Refugees, as well as a wide array of governments, activist networks, and non-governmental organizations, sought to address the gap that currently exists in international law, particularly international refugee law and international human rights law, in regard to cross-border movements resulting from disasters and climate change. The problematic nature of this gap had been raised in the outcome agreement prepared at the 2010 United Nations Climate Change Conference in Cancun, which among other things had invited states to adopt, quote, measures to enhance understanding, coordination, and cooperation with regard to climate change-induced displacement, migration, and planned relocation where appropriate at national, regional, and international levels. After its final recommendations, expressed in a non-binding promotion agenda, were endorsed by a large number of states, the Nansen Initiative was succeeded by the Platform on Disaster Displacement, a similarly structured follow-up organization that builds upon the work of its predecessor to construct what it touts as a holistic legal approach to, quote, humanitarian assistance and protection, human rights, migration management, refugee protection, disaster risk reduction, climate change mitigation and adaptation, and development. A lot of things bundled up there. Now, efforts of this kind are proliferating rapidly, and they signal an increased desire to design and implement organized movements through fundamentally managerialist means. When all is said and done, climate change is a product of transformations in the metabolic relation between nature and humanity that Marx saw as key to capitalism's operational logic, and that contemporary legal theorists like Jedediah Purdy place at the forefront of their accounts of the Anthropocene, the current geological age marked by a significant growth in the impact that human life has on our natural environment. As a result, it should come as no surprise that many feel that climate change-induced forced migration needs to be managed preemptively rather than reactively, brought within the fold of an international legal regime that will contain its consequences through tried and true best practices. After all, if climate change and the countless humanitarian, economic, and security crises that will come in its train stems from humanity's unfettered exploitation of the world's resources, what could be more logical than to expect humanity itself to mitigate its effects? even if this entails, of course, effectively compulsory migration, sometimes on an enormous scale. In this connection, it's important to bear in mind that the international legal landscape in which mass relocation programs like the Greek-Turkish population exchange were undertaken is significantly different from the international legal landscape in which contemporary projects like the Nansen Initiative are beginning to take root. Unlike the legal context in which the Greek-Turkish population exchange unfolded, compulsory population transfer is now widely understood to violate international law, especially international humanitarian law, international human rights law, and international refugee law. Express prohibitions or language with roughly similar constructive effect can be found in a slew of legal instruments today. The Universal Declaration of Human Rights, the Genocide Convention, the Fourth Geneva Convention, the 1951 Refugee Convention, the Rome Statute of the International Criminal Court, the Draft Declaration on Population Transfer, the Implantation of Settlers, the International Law Commission's Draft Code of Crimes Against the Peace and Security of Mankind, and its draft articles on the expulsion of aliens, and a whole variety of others. What's more, international legal scholars today routinely characterize mass expulsion as an anomaly, a throwback to a cruder and less sophisticated age. Yet, despite such opposition, population transfer and broadly analogous forms of demographic engineering, both domestic and international, continue to be implemented or at least entertained in a significant number of states. Legal legitimacy is nearly always sought for such exercises. That's important to note, particularly when they're couched in voluntary terms. If a member of the Institute of International Law, an eventual judge of the International Court of Justice, could argue in 1952 that, quote, from the point of view of international law, there exists in this matter absolute freedom of action on the part of states, provided that the laws of humanity are not violated, so too could a UN rapporteur who was until recently a judge of the very same court argue as late as 1997 that in certain contexts, quote, population transfers are lawful if they are non-discriminatory and are based upon the will of the people. It is not easy to imagine many circumstances in which entire peoples or nations would voluntarily agree to permanent cross-border relocation. And the tenability of a strict distinction between compulsory and voluntary transfers is complicated by the fact that the latter, voluntary transfers, are typically accompanied by high levels of desperation, persecution, or intimidation, making migration effectively compulsory even when it's not explicitly characterized or labeled as such. But international law arguably continues to permit reliance upon population transfer when such willingness is or is deemed to have been expressed freely. Now, it's precisely here that organized resettlement undertaken in response to some of the most extreme consequences of prolonged climate change reveals its distinctive character. No treaty or other binding international legal instrument currently addresses climate refugees directly and specifically. And in most cases, where states have expressed support for mass resettlement initiatives as a possible future response to climate change, relevant officials have taken pains to stress the voluntary nature of resulting displacements. Indeed, according to Elizabeth Ferris and Jane McAdam, both of whom have studied climate change's consequences for international refugee law extensively, no state, quote, no state is presently advocating relocations across national borders. They are doing so only in expectation of possible future need. And, quote, even states that recognize that international movement may at some point be necessary tend to emphasize voluntary migration. So they themselves give the example of Kiribasa's Migration with Dignity initiative as an example. That serves as their chief example. Such adherence to the distinction, the conceptual, analytical distinction between compulsory and voluntary movements may certainly make for a certain degree of tidiness. But once again, and this is something that McAdam and some other international refugee lawyers also note, the distinction is exceedingly difficult to sustain in practice. Absent armed conflict, systemic poverty, state repression, persecution of minorities, and a variety of other factors, including crucially climate change, it's hard to see why whole peoples would express en masse their willingness to abandon their homes, which it bears reminding are sometimes ancestral lands, and resettle in entirely different countries. At root, however many euphemisms we may use, organizing mass resettlement initiatives for reasons of climate change is a form of legally formalized population transfer, and one that's likely to be underwritten by a considerable measure of coercive force at that. We may well be uncomfortable with that characterization, given the disrepute into which population transfer has fallen in the past half-century, but that doesn't change the fact that it's in many respects the most accurate and appropriate descriptor. Ultimately, whatever we may happen to think of the desirability or even necessity of organized resettlement initiatives as a way of coping with climate change, what we are dealing with here is legally authorized mass displacement, expulsion. Okay, so that brings us to the European Union's refugee deal, the so-called refugee deal with Turkey. Quite controversial these days. For some time now, the European Union has been in the habit of concluding so-called readmission agreements with a variety of non-member states. Arguably, the most comprehensive such arrangements have been concluded with Turkey, a state that currently hosts nearly 3 million from Syria alone, and from which exceedingly large numbers of refugees and migrants regularly seek to enter Europe, often with the assistance of local networks of human traffickers. The latest and most controversial agreement, concluded on March 18th of this year, extends, augments, amplifies previously existing commitments, and was prepared with the aim of addressing the ongoing surge in the number of those seeking refuge in the EU, Europe's so-called refugee crisis. The March 18th instrument, formerly a mere statement rather than a treaty or even an agreement, right? The wording makes a difference, is too complex and also too idiosyncratic, too eccentric for me to be able to do justice to it here. I do, however, want to take note of 3 basic characteristics of the instrument. First characteristic, the March 18th instrument stipulates that all new irregular migrants, this being a conventional quasi-legal euphemism for those seeking to travel across international borders without the requisite documents or authorization, all new irregular migrants crossing from Turkey into Greece will be returned to Turkey effective March 20th. Returned is actually the lingo that appears in the statement. In practice, this means that Greek authorities have the right, as per the EU's Asylum Procedures Directive, to compel Turkey to readmit all irregular migrants who have either not applied for asylum or had their application rejected. The EU itself is to foot the bill for all such readmissions. Tellingly, this readmission procedure is glossed by an assurance to the effect that it will unfold, quote, in full accordance with EU and international law, thus excluding any kind of collective expulsion. And that migrants will be, quote, protected in accordance with the relevant international standards and in respect of the principle of non-refoulement. Non-refoulement is the legal principle prohibiting the forcible return of a refugee or asylum seeker to a state in which she or he is likely to face persecution. Of course, as is so often the case, the trouble with this assurance is that it is both dubious and disingenuous for reasons that will soon become apparent. Anytime the drafters of a treaty or similar international legal instrument sort of bend over backwards to point out that it's in compliance with international law, you should be suspicious, right? So that's the first point. The second point is this. The deal is premised on the augmentation of the so-called 1-1 scheme, a migration policy according to which the EU agrees to accept a Syrian refugee currently in Turkey for every Syrian who is returned from Greece to Turkey, with priority being accorded to those who have not entered or attempted to enter the EU irregularly on previous occasions. There's thus a kind of structural reciprocity undergirding the legal cum administrative regime envisioned in the March 18th instrument. Since the overarching objective of the arrangement is to further securitize the EU's vulnerable and predominantly maritime southeastern border with Turkey, one of the most significant transit countries for many refugees and migrants from the Middle East and elsewhere, people are to be treated like commodities, or even worse, as cattle, to be swapped and shifted in accordance with wider economic interests and geopolitical concerns. The refuge and resettlement a fundamentally technocratic business of burden sharing. The fact that Turkey has recently moved to prevent university-educated Syrian refugees from resettling in the United States adds yet another wrinkle to this story. Third point here, the entire arrangement is nominally contingent upon the acceleration, or as the statement itself prefers to put it in standard Euro legalese, the re-energization of Turkey's protracted and seemingly asymptotic process of acceding to the EU. A process that was inaugurated with formal negotiations in 2005, but that has resulted in an agreement on no more than 1 out of the 35 chapters of EU law that every candidate country must absorb into its domestic legislation before it may become a member state. The March 18th instrument promises to upgrade the existing customs union between Turkey and the EU, states that the EU will speed up the liberalization of visas for Turkish nationals, provided that Turkey satisfies certain benchmarks, particularly in regard to reforming its draconian anti-terror laws, and commits the EU to make a previously promised 3 billion euros, as well as a further 3 billion euros in fresh funds, available to Turkey for the purposes of assisting with refugee protection. Many have accused Turkey's reigning Justice and Development Party, an authoritarian Islamist organization that has curtailed civil liberties, crushed Kurdish and dissident groups, and eliminated most independent media outlets, of engaging in a kind of blackmail in order to obtain these and other concessions. After all, President Erdogan and a number of his ministers have repeatedly stated that Turkey will suspend application of readmission practices if the EU drags its feet on visa liberalization and material assistance. For its part, the EU has been accused of hypocrisy and illegality, with international refugee lawyer Vincent Jetai remarking that the March 18th instrument illustrates the policy of containment carried out by the EU for the last several years in order to avoid its responsibility towards refugees. Clearly, the March 18th instrument is no ordinary treaty or instrument for refugee resettlement or repatriation. Indeed, in addition to the problems that I've already noted, the instrument has been criticized on a number of additional or supplementary grounds. For one thing, the instrument was not discussed or approved formally by the European Parliament. Instead, it was negotiated by the heads of state or government of the European Council. Many have argued that this amounts to a fundamental circumvention of basic rule of law requirements, feeding long-standing concerns about the elitism and unaccountability, the non-transparency of EU institutions. For another thing, the document is capable of being read as both an international treaty and a non-binding arrangement, with its ambiguous language lending a measure of credence to both interpretations. I favor the latter interpretation, as do most international lawyers, but both interpretations are possible, at least theoretically. This bolsters the suspicion that it was prepared with a view to minimizing oversight and informed discussion on the part of the broader public. Still more fundamental problem stems from Turkey's putative status as a safe third country. So long as Greek authorities deem Turkey a safe third country for purposes of refugee protection, the terms of the EU's Asylum Procedures Directive permit them to deem asylum claims of refugees arriving from Turkey inadmissible following a relatively threadbare interview process. This clearly raises a host of serious legal issues. Given its abysmal human rights track record, its weak history of compliance with international refugee law, and the highly precarious employment and educational conditions for refugees within the country, not to mention the authoritarianism of its current administration, the ongoing conflict between state security services and Kurdish militants, the threat posed by ISIS terrorism, and last but not least, the instability and crackdown measures fostered by the failed coup in July, it's anything but clear that Turkey is genuinely capable of being characterized as a safe third country, one in which refugees would not face significant risk of persecution, torture, inhuman and degrading treatment, or removal to another country in which they would be at risk of serious harm. In fact, in May of this year, an independent Greek tribunal entrusted with the authority to consider appeals of decisions about asylum applications ruled that a Syrian refugee could not be returned to Turkey. The refugee at the heart of that case was one of the first who had been earmarked for compulsory deportation. And the tribunal's ruling has the potential to serve as a key precedent, as a watershed for a large number of other cases. Even more generally, there's widespread concern that the March 18th statement is essentially a means of facilitating mass expulsion from a new fortress Europe, one whose territorial frontiers are policed not simply by NATO and national military forces, but also and increasingly by Frontex, the European Agency for the Management of Operational Cooperation at the External Borders, the European Border and Coast Guard, a border control and management organization that has effectively begun to reform and restructure Frontex, and a variety of related supranational agencies and organizations. So widely is this concern felt that a number of human rights groups and international organizations, the Office of the United Nations High Commissioner for Refugees, Oxfam, Doctors Without Borders, and Save the Children, to name but a few, have periodically suspended some of their operations in Greece precisely in order to voice their opposition to the deal and prevent the deportation of displaced persons to whom they provide assistance. Finally, it's important to note that the March 18th instrument and the earlier readmission protocols with which it's associated does not simply facilitate deportation from Greece to Turkey, it also encourages the very migration from Turkey to Greece that it's designed to combat. Since the March 18th instrument is premised upon the augmentation of migration controls and the systematic deportation of irregular migrants who have entered the EU, it indirectly reinforces the power of smugglers in Turkey and other non-member states who continue to move large numbers of migrants across the Aegean and the Mediterranean. Unable to access Europe through legal channels, many migrants are left with no choice but to rely upon the resources and the expertise of these local traffickers, paying large sums of money to make the voyage to Europe, oftentimes on rafts that are typically unreliable and poorly constructed. The March 18th agreement is currently in a state of limbo, the object of protracted and serious legal and political bargaining between Turkey and the EU. enshrining what one commentator has rightly termed a trade in human misery. The instrument cloaks global capitalism and regional securitization in the veneer of global humanitarianism. And crucially, it's through the formal mechanisms of international law that this merger is achieved, consolidated, and operationalized. Once again, what we have here is a new form of population transfer, all the more brutal and insidious for not being recognized and repudiated as such. So here, I'm going to conclude. I'm sweating too much. All right, at this point, you may be wondering what concretely and precisely we're supposed to make of all this. After all, the population transfer treaties of earlier periods, earlier epochs, may make for fascinating historical analogs, but at first blush, they seem to bear little direct resemblance to the myriad overlapping forms of displacement that characterize the world today. Climate change, refugees, readmission agreement style stuff, all different kinds of things. In other words, right, we can kind of transform the question as follows: why history? Why do history at all? Well, Antonio Guterres, until recently the United Nations High Commissioner for Refugees and presently the incoming United Nations Secretary General, has recognized as much, stating that it's becoming increasingly difficult to rely upon inherited legal categories when seeking to understand and develop policies in response to displaced persons, given the range of different factors that are usually at work in the generation of large-scale flows. For some time now, scholars have argued that the 1951 Refugee Convention, still far and away the most important instrument of international refugee law, is in need of revision. Its post-1945 framework anachronistic and utterly insufficient in a world that's increasingly organized around the plight of those forced to flee war, social and economic deprivation, the effects of climate change, and so on. And that goes even with the 1967 optional protocol. What has not been understood, though, at least not widely and satisfactorily, is that many of the solutions being floated in response to the forced migrations of today and tomorrow trade on the coercive power of yesterday's population transfers. Notwithstanding the obvious formal discontinuities on the level of the relevant legal instruments, a significant degree of substantive, or if you like, functional continuity can be discerned between them. It's crucially important to appreciate this, we think, Itamar and I, not least because history is one of the most effective means of casting doubt on the prudence and the legitimacy of seemingly innocuous exercises in organized mass migration. Here, exercises in disaster response and border security. Far from being of merely historical importance, this is a lesson for the present, and even more so for the future. So I'll stop there. I'm truly sweating too much.
Thank you for that talk. First of all, let me excuse myself. I'm going to have to leave in a few minutes because I have a compulsory meeting.
No. Totally understand.
I wanted to ask, so thank you for
thank you.
And obviously the work you've done. Two situations come to mind which I think present challenges.
Right.
And I share your view that in principle forced transfer populations prohibited under international law, and leaving aside international law is hugely problematic for lots of different reasons. Nonetheless, two cases, and they're completely different and respond to different contemporary challenges. The first was the factual experience of the mass movement influx of refugees, actually conflict refugees from Kosovo into Macedonia.
Right.
I think 1999 or whatever that was, 2000, I can't remember the year. And at that time, they suddenly came in en masse and affected at that moment, if they were to remain, and there was a fair chance they might remain for some period of time, a significant change in the population ratios in Macedonia. You may know the nature of the ongoing tensions and problematical issues of ethnic Macedonians versus particularly ethnic Albanians. So these are overwhelmingly ethnic Albanians coming into Macedonia. So much so that the Macedonian government, and also just at a popular level, there was an immediate reaction and mobilization of militias and things to the northern frontier for the idea that they may push them back.
Right.
And so you had the real prospect of violence on a mass scale. And at that point, I can't remember who was the British general. I think it was Rose, who made a determination on his own judgment to put these refugees into buses and forcibly moved
Right.
them into Albania and Montenegro, I think. Now, you may know that that is itself a breach of international law.
Right.
He didn't ask them where else they wanted to go. He didn't give them any choice. He just moved them
Right.
to a third country. Clear breach of international law. Many, many people think, thank God he did it.
Right.
Okay, because the alternative was much worse. And as a matter of fact, things did normalize in many respects. We subsequently had the quote independence of Kosovo, or well, what has happened and what
Right.
will continue to do. So I think that's one question. It has nothing to do with climate change. I mean,
Absolutely. Yeah.
we have a problem here. Maybe what Guterres is talking about, that the kind of established international legal regimes don't necessarily
Absolutely.
respond to some of the challenges we're actually facing.
Absolutely. Yeah.
And it does connect still with ideas, I mean, obviously in Macedonia, ideas of the definition of the state, the place of Macedonia and so forth. One case. Second case, the Maldives. So the Maldives, the funny situation, as you may know, where the overwhelming territory of the state, I think the highest point above
Right.
sea level is 1.5 meters. The capital, where 2/3 of the population lives, is itself, at a meter at the highest point. And so Maldives government, you may know, has actually purchased land
Yep.
in Sri Lanka, and is actually looking at the prospect of not only relocating population, but the whole question, what would be the character of that population, territory, and the population in that territory. Is that, they're purchasing it as a sovereign act, but would they then confer kind of diplomatic protection over this territory? Are they, in a sense, or would they actually make a normal deal, like the Americans bought Alaska? Could they just have a cession of some sort? Uncertain. But at some point, there's going to be a real question about moving population. And I agree with your point to be suspicious of voluntariness, but I would say, and I've worked in the Maldives, there may be a genuine voluntariness to this. There's lots of people already have close relations with Sri Lanka and so forth, have interest, business. So on the basis of both these cases, I suspect you're overstating, though you're merited in being suspicious, that not only this absolute prohibition of forced population transfer, but to dismiss entirely the idea that there may be organized population transfer. I think it might be something we're going to face if you look at Bangladesh,
Right.
the third case, and so forth. So shouldn't we be talking about what would be the new structure of international law and relations that would actually respond coherently to the challenges and consistently with the fundamental values of international relations and law, but not be so dismissive of saying, this is just wrong, can't happen.
Can I respond? Yep. So this is actually great, terrific, and thank you very much. This is exactly the kind of feedback that we were hoping for. So I'll take the first question relating to Kosovo. It's actually interesting because a lot of the work that I'm currently doing in the context of decolonization has to do with the sort of historical preconditions of this illegal but legitimate standard or formula that was devised in the wake of NATO's bombing in Yugoslavia in 1999. During the course of the Kosovo conflict, a decision was made, or a series of decisions were made, to undertake actions that constituted clear breaches, clear violations of international public law, in particular the international law on the use of force, right? But that were regarded as morally legitimate or indeed morally necessary in some sense. Not simply politically pragmatic, politically prudent, but morally necessary, called for under the circumstances. Now that's an interesting approach, and it's one that gets kind of canonized in the Independent International Commission on Kosovo's report following the conflict. So this is people like Richard Falk, noted international public lawyers with vested interests in seeing to it that third world rights to sovereignty are taken seriously. So this is interesting. Nevertheless, having recourse to this idea that certain things can constitute violations of international law, but nevertheless fly. And in situations like that, international lawyers oftentimes have begun to sort of resort to this idea that, well, you should just back off. You know, you shouldn't necessarily try to bring the breach or the violation within the contours, within the framework or parameters of existing law, so much as you should just sort of hold off, reserve judgment to some degree, because there's a sort of political necessity there that needs to be taken seriously. There's an interesting structural similarity here, I think, in the case that you mentioned with Macedonia. The forced population transfer, you know, no one is asking these refugees, you know, where they want to go, or whether they want to be transferred, and so on and so forth. But out of humanitarian concerns, and humanitarian concerns are never simply humanitarian concerns. They're about securitization. They're about, you know, the restoring of stability to a state or a set of states or an entire region, so on and so forth. You know, those people get moved. So the concern that I have is that, you know, the moment you move away from the letter of the law, as it were, and the letter of the law is never entirely the letter of the law. It's ambiguous. It's shot through with tensions and contradictions, you know, granted. But the moment you move away from that blanket prohibition, that across-the-board formal prohibition, you are opening up the terrain to what we've seen since then, right? So the Kosovo approach, the self-styled Kosovo approach, illegal but nevertheless legitimate, has been deployed by the likes of Putin in the context of the Ukraine crisis. It's been deployed by pretty much all parties in Syria, which has now become sort of proxy conflict. It has underwritten, I would argue, the notion of R2P, responsibility to protect, which more often than not is so flexible, so overly generous as to capture a whole variety of different, a whole variety of acts that, you know, perhaps it wasn't, it ought not to be capturing. Let's put it that way. So that's the difficulty. That's the difficulty. I'm not necessarily saying, and I don't think Itamar would necessarily want to say either, that under no circumstances can population transfer be undertaken. The point that we want to make is that population transfer is always about stabilization, securitization, and generally looped up, bundled up with with relations of domination and exploitation that can only be understood from a neo-Marxian standpoint. And it's about the coercive power of states or state-grounded international organizations, state-produced international organizations seeking to stabilize, to securitize, and usually to open up markets. So, you know, this is the general argument that we want to make.
Isn't true of the two cases I gave. So I'm with you all
Yeah.
until you get to, you said only and always.
It's as a general matter, as a typical matter, yes, absolutely. So, I mean, the Maldives case, the second case, is interesting in this respect as well. It raises a huge number of concerns from bread and butter, kind of nuts and bolts international public law. I mean, how does a state disappear?
Right.
You know, the creation of states is already problematic enough. Is it a factual process? Is it a purely legal process? What, in fact, would that? What really would that mean if we're to understand it that way? Is it some strange amalgam or combination? If so, you know, what is specifically factual? What is specifically juridical? You know, very, very messy, very, very controversial at the best of times. The dissolution of states is similarly messy, but here you have the disappearance of states, the factual disappearance of a state. Now, I don't want to discount the possibility that under circumstances like that, and indeed it seems more likely than not that unfortunately we're going to see various forms of this in the future, something like population transfer could indeed be couched voluntarily, could indeed signal some genuine consent or will on the part of the people in question. But I think that's actually very much an exception, not a norm. Not something that's even broadly representative of the normal situation. You know, if you take a look at development-induced displacement, for example, it's very, very much a rarity to see entire communities or sets of communities, entire peoples or nations succumbing or agreeing to acquiescing in their forced transfer, whether internally or cross-border transfer. You know, whether through referendum or plebiscite or through less formal means or whatever. You know, it's a very, very rare thing. So I'm not going to discount the possibility that it can in fact happen. And if there is, you know, if there is a formal process that does give expression to that sort of mass level consent, and the mass level consent is indeed mass level, it's something that reaches all sectors of the society in question, then perhaps. But again, the point there that I want to make is that it's a state coercive mechanism. It's a state coercive technique, first and foremost. Right? Here you have acquiescence in that technique. And that's the interesting thing in terms of sort of telling this structural historical story that we're trying to signal here. I'm not discounting the possibility that under certain circumstances people could provide their consent, but I think it is very much an exception. Oh, sure.
I don't know, we can't both do this.
I saw a hand in the back. I'm not wearing my glasses, so it's just a sort of blob. But
one of the personal aspects of your talk that strikes me is that my father's family was ethnic German in Hungary and was part of this movement that you're discussing here, people being shuffled around.
Thank you.
And ended up going back home supposedly to Germany, right, after the Second World War. Ended up in Canada as a result. But in terms of a ill-formulated question that I can put together, I'm thinking specifically about Canadian history of forced migrations within Canada, especially of Indigenous populations.
Absolutely.
And the kind of reoccurring, more popular stream of thought that happens, so it's maybe more of a grassroots.
Yep.
Every time there's a crisis, and especially an isolated Indigenous community in the North, there's some kind of editorial that probably gets a lot of clicks. Written by somebody like Scott Gilmore, who advocates for the removal, supposedly voluntary removal of those people to another location because it's a location problem.
Absolutely.
And so I guess my question has to do with the kind of popular ideas about solving problems and moving people around and how that's related to top-down legal ideas.
Absolutely. So I've been struck by this as well. I have the misfortune of having signed up to Twitter a couple of years ago, and now I'm just stuck with Twitter because if I don't go on Twitter, then my wife says, you're just being horrid. Unleash on Twitter. Just rant on Twitter. I'm tired of listening to your rants and so on. So that's what I do. And in the context of episodes like this, you always see a deluge of tweets and links to op-eds and so on and so forth, saying more or less the same thing. In the Canadian context, but also elsewhere. In the Canadian context, it's particularly it's particularly common. It tends to be because you have this idea that beyond a certain point, Canada is fundamentally uninhabitable, and that the populations who do inhabit those areas are fundamentally unfortunate for inhabiting those areas, and that they should be moved, if necessary, by force. So this idea, as you note, seems to sort of exist in some sort of a subterranean, or not always subterranean, really popular consciousness, and it finds expression the moment one of these episodes really comes to the fore. I haven't given much thought to that phenomenon in and of itself, I must say, but population transfer definitely overlaps with the expulsion and displacement and dispossession of Indigenous peoples in Canada, but also in a whole variety of other countries and regions. Those implications are very much there to be teased out. In most cases, of course, those expulsions, those displacements have taken place within the contours, within the legal frameworks of existing or settled states, or states that at least claim to be existing and to be settled, and whose fundamental borders and parameters are beyond question, and so on and so forth. So they're not cross-border relocations, typically. Typically, historically speaking, they're relocations within states. So, the phenomenon that Itamar and I are really concerned with is international, legally formalized, legally mediated, and typically compulsory population transfer. We try to problematize that distinction between compulsory and voluntary along the grounds that I sketched in the paper. Here, typically, not always, but typically you have something slightly different. You have internal relocation schemes no less brutal, no less violent, no less grounded in domination, exploitation, the dispossession of whole peoples, cultural genocide, genocide, not simply cultural, the whole lot. But structurally speaking, mechanistically speaking, slightly different. But yeah, no, I agree. I've seen this this wave, this deluge of broadly popular sentiment with every one of these episodes. Why not simply move those people to the south? Yeah, this is the common sentiment.
Thank you. Thank you very much for your presentation. I had just a question because I fully take your point. I mean that this agreement between Turkey and the European Union is disgusting, as are many readmission agreements between the European Union and other states. And this idea of non-refoulement and all of that. My question really is, do you think there would be an appropriate response from an international law perspective to this, forced migration? An appropriate response, because the reality is that, as you know, more than 90% of refugees are in developing countries, and yet our states are unwilling to make their own contribution. Also, there is clearly the case that when people come to our border, we do everything we can to remove them, and that's of course a very complicated case, because the state also has a responsibility to make sure that we are actually also protecting our own population and all of that. The key point that I want to make is that international law right now is very weak when it's time to coordinate an appropriate response in terms of responding to the so-called forced migration of those people. We have refugee law, and that's pretty everything. We have smuggling and trafficking international legislations. But it's also a problematic case here, because there is a lack of coordination through international law between states to deal with those forced migration situations. So I just wanted to hear your thought as to whether you think there would be an appropriate way to address the situation from an international law perspective, rather than from a unilateral or bilateral perspective.
It's the big question, and it's the question that I want very much to avoid. Not simply because it's impossible to answer, but because this paper fundamentally is trying to do something slightly different, right? It's trying to warn of the possible consequences of prioritizing a particular form of response to migration flows and new kinds of migration flows. That, while not recognized as such, typically owes much of its conceptual pedigree to a whole variety of episodes that have now been denounced as beyond the pale of international law, so to speak. Okay? So I don't have an answer to this, to be perfectly frank. I don't have an answer to the question as to whether international law has the resources at its disposal to respond or to carve out a comprehensive response to the refugee phenomenon in all its myriad forms on a go-forward basis, as well as climate refugees come online and so on and so forth. And I also don't have a response to the question as to how that would happen, or what form, what shape that would take place. What I can do is simply caution, on the basis of historical experience, caution against the heavy reliance upon certain forms of certain kinds of responses. So here, one of the things that really jumps out is, Turkey is really doing a lot of the work in this paper, right? So the Greek-Turkish population exchange, of course, not so much in the context of climate refugees, but certainly in the context of these readmission agreements. So readmission agreements have been concluded by the EU with any number of other states, but the ones with Turkey really end up doing a lot of heavy lifting, and they typically end up sort of serving as precedents, almost as templates, really, for a lot of other states as well. The thing that's interesting here is that Turkey, while a state party both to the 1951 Refugee Convention and to the 1967 optional protocol, has, like many other states, it's by no means alone in this regard, made reservations to its membership in that treaty regime. And You know, the 1951 Refugee Convention was meant to apply to events that had occurred prior to 1951. It was also meant originally to apply, this is stated explicitly in the surface of the text, there was a geographic limitation. It was meant to apply to events that occurred within Europe, in Europe. 1967 optional protocol addresses that, or tries to address it, removes the temporal and geographic limitations, but also gives states the option of making reservations to maintain those limitations or to hedge, to contain the applicability of the removal of those limitations to themselves. So that's what you have in the case of Turkey. Turkey actually maintains not the temporal limitation, not the stuff about 1951, but the geographic limitation. It says, you know, refugeehood is something that is fundamentally European in a sense. Legal refugeehood obtains in the case of, you know, those who, you know, have fled Europe, but in the case of, you know, Syrians or others, you know, moving into Europe or seeking to move into Europe through Turkey, which again is the principal transit country. Libya and others are key transit countries as well, but Turkey is a main transit country in this respect. Not so much. It becomes dicier at any, you know, at any rate. So I signal that. I make a point of mentioning that simply in order to, you know, note the difficulties. I won't say it's impossible, but the difficulties certainly in forging a comprehensive treaty regime at the best of times. Right? Large-scale multilateral treaty regimes are incredibly difficult to work out, and the only way you work them out, we've seen this in the context of climate change, strictly speaking, right, with Kyoto and the Paris agreements and so on. The only way you actually hammer these things out is by diluting you know, the force of the relevant provisions, or by diluting the language that you insert into the relevant provisions in such a way that it captures a whole variety of different approaches. You know, the more vague, the more imprecise the language is, you know, the less compelled states will be to refrain from entering that treaty regime. And the more precise, the more stringent the relevant language is, you know, the more you're encouraging or even inciting states to say, well, you know, we're not going to actually have at this. So oftentimes this is what you get. You know, the idea of a multilateral treaty regime that updates, reforms, and restructures the 1951 Refugee Convention, and that is precise, that is stringent, and what exactly that would mean, right?
And you know that many people say that if we had to come back to the 1951 Refugee Convention, we would have that many states. We need
Right,
to sign
exactly.
for that type of treaty.
I mean, we have to understand.
What the current context is right now.
Yeah, absolutely. We have to understand the singularity, the specificity of the post-Second World War context. I mean, this is, a lot of the second book has to do with this post-Second World War wave of decolonization. The reconstitution of territories that were once subject to colonial imperial regimes of one sort or another as independent sovereign states, and what international law has to say about all that. So state succession to treaties, and permanent sovereignty over natural resources, and the reconceptualization of self-determination, this collective right or principle, all that kind of stuff. So much of what we have today owes its origins, at least rhetorically speaking, if not institutionally or organizationally, to that period, that 5 to 10 year period after 45, right? I mean, international criminal law, international human rights law, international refugee law. Sam Moyn, in my view, very rightly has pointed to the 1970s as a key decade for the breakthrough of human rights from an organizational standpoint. You get Amnesty, you get Human Rights Watch, you get the Carter administration doing its thing, and so on and so forth. But rhetorically speaking, legally, textually speaking, of course, you have the Universal Declaration, you have all that stuff in the 40s and 50s. You have the two Human Rights Covenants in the 60s. So yeah, I mean, that's a formative, highly generative period, and it's highly specific. You know, 2 world wars, tens of millions of people who have lost their lives, entire continents rent asunder, the Holocaust, even if the Holocaust, Holocaust memory hasn't really come into its own yet, the decimation of entire peoples. It's a very specific period. Hopefully, hopefully we won't experience something analogous today or in the near future. Oh, yeah.
Yes, I really really enjoyed
Thank you.
your talk.
Thank you.
It's historical, going back to history and to look at the present. I really enjoyed that, and I would like to push you a little bit on that, because I'm also interested in comparing historical moments of migration crisis with current ones. And I was wondering if you would go as far as saying that perhaps this population transfer, forced population transfer, was never out of the picture, even during 1951, 52. Because
Absolutely.
if you think of the creation of the International Refugee Organization, there were debates between states as to what was the purpose of this and what were the solutions that were pushed forward.
Absolutely.
And a lot of this was resettlement, but resettlement seen as a strategy of demographic change, or bringing the most the intellectual and so on and so forth. And so, I would just like to hear from you what you think about this. If that was something that was always there, but with different understanding, and which means that perhaps the human rights understanding of refugee protection was one of the possible solutions, but it was always present in the background, economic or sovereignty purposes.
This is exactly. So I mean, my argument in my previous work, but the argument that Itamar and I are running in this paper does not make the claim that population transfer disappeared as a political fact, or as a political process, or as a political technique, political cum legal technique that was deployed in a whole variety of different contexts, right? So British India being rent asunder, the formation of India-Pakistan, the creation of the State of Israel, Cyprus, Yugoslavia, all of those examples, and many others. We can think about all those things. The argument that we try to run is that from a specifically doctrinal legal standpoint, population transfer gets pushed to the margins. It gets relegated to the sidelines, right? It's something that, from a sort of canonical authoritative point of view, when you look at the canonical authoritative international treaties, particularly the international human rights, international criminal law treaties of that formative period, the 1940s and 50s, population transfer is something that, compulsory population transfer is something that gets delegitimated in a very marked way, right? It gets rendered unlawful. Nevertheless, it is used time and time again, but it's simply re-signified, reconceptualized, or at least sold, marketed as something else, or as some other set of things. So compulsory, well, it's not truly compulsory, it's really voluntary, and if you look at the population enough, you'll see that it's voluntary, and the will and consent of the people has actually been hit up, and they've expressed it, they've given expression to it. Or it's not really about population transfer, it's about, this particular securitization initiative that was necessary, and that's also justifiable within reasonable limits because it's proportional to, blah, 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 right? These sorts of arguments get run constantly post-1945. So population transfer is very much alive and well. In fact, population transfer really comes into its own as a political technique post-45, right? Which is precisely what makes the Greek-Turkish population exchange of the interwar period, the 1920s and 30s, so interesting. Because it's this, along with other transfers and exchanges in the Balkans and Asia Minor in the 19-teens, Greece and Bulgaria, Greece and Turkey, and so on, most of which never really got implemented. It's this sort of locus classicus, it's this generative period, the precedential implications of which unfold, and are allowed to unfold, by no less, figures of no less authority than Winston Churchill after 1945. Okay? So population transfer is alive and well, but legally speaking, it gets cast to the margins. It's outlawed. It's outlawed, but it's used that much more extensively, and it gets globalized as well. So it's not really contained geographically, regionally speaking, to the Balkans and Asia Minor in the way that it is when it originally really comes online as an internationally coordinated, legally mediated form of nation building. It gets globalized, and it gets picked up by states that, previously in the League of Nations period and prior to the League of Nations period, would never have dirtied their hands with it, or wanted to dirty their hands with it, at least explicitly. Notwithstanding the massive expulsion of indigenous peoples and other peoples everywhere. So I mean, that's my sort of my basic crunch. I may have the one thing that I did want to note, I just jotted it down while you were asking a question, is this. So Mark Mazauer, I differ from Mazauer's account of the formation and constitution of the United Nations in some important respects, but what he really hits very, very nicely is, I believe this is chapter 3 of his book, No Enchanted Palace. He hits very nicely this distinction between population transfer and genocide and other forms of individualistic human rights and collective human rights being reconceptualized after 1945, right? So Joseph Schechtman is the person that he singles out as a kind of leading exponent or advocate of population transfer post-45. Before 45 as well, but really post-45. This is one approach to nation-state building, to forging stable states and regions with a view to curbing conflict, with a view to shoring up and ordering that much more profoundly the international system. But another approach is the one that eventually wins. That's the approach that really, he personifies in the form of Raphael Lemkin, of course, the leading exponent at the time of the concept of genocide, the person who really gets the Genocide Convention ultimately adopted. But there are a whole variety of other folks as well. So I'm doing work at the moment on someone by the name of Egon Schweb, who's basically one of the leading sort of builders of the human rights system at the United Nations. He's the person who does a lot of the heavy lifting behind the scenes. He doesn't always get credit for it. Lauterbach and all these people get the credit for it, but Schwab is really doing a lot of the sort of logistical and technical heavy lifting for that. So genocide, individualistic human rights, that carries the day. But population transfer is very much on the table. It's very much sort of in the cards at the time, as you see at Potsdam and the expulsion of the Germans from Eastern Europe and so on and so forth. So yeah, our argument is on the level of the structural analogy over time between these different, otherwise different episodes. And it's trying to tease out the transformations of international law along that process. So international law transforms, right? Population transfer falls out of favor among international lawyers. But population transfer actually becomes, if anything, that much more fashionable, that much more popular over time. So, kind of a crude response, but yes.
Thank you. I'd like to better understand how you define international law, this concept of international law, and what interaction you see between international law and international politics. Me personally,
Yeah.
I have trouble seeing the world through international law glasses.
Yeah.
And maybe it's because we don't define international law the same way.
It's a huge question, and I'm afraid I have to dodge this one as well, or evade it. I don't have a catch-all satisfactory or adequate definition of international law. International law, Marty Koskinemi likens international law to a language, right? And this goes to the distinction or the relation, the structurally tense relation between international law and international politics, for him and more generally. Marty Koskinemi, leading international legal theorist and ex-Finnish diplomat as well, says, look, international law is best understood as a language. It's not rational, it's not defensible to say the English language or the French language or the German language or the Arabic language is good, fundamentally, intrinsically, inherently good, or fundamentally, intrinsically, inherently bad, for that matter. Doesn't make sense. Doesn't make sense to speak of a language in that way. So too, international law, and law more generally for him. Right? It doesn't make sense to say international law is good or is bad, is effective or ineffective. It's a language. It's a language that can be used and abused, that can be interpreted and applied by all and sundry, in all variety of different circumstances. In some cases, those the usages of international law as a language are ones that we're going to throw our weight behind for any variety of background political commitments that we have. In some other contexts, maybe not, right? But it functions as a language. Now, this is an interesting approach. It's not an approach that I feel entirely comfortable with on every level, but it is quite suggestive, and it goes to the sort of ancillary question that you were asking about the relationship between international law and politics. To deny the political nature of international law would be to misunderstand and mischaracterize international law fundamentally, right? So law is distinct on some level from politics, from economics, certainly from morality and so on. It has certain formal attributes or properties that render it distinct. But it's certainly not distinct in the sense of being absolutely separate from all of the rest of these things. It's intrinsically wedded to, bundled up with these other things. So the approach that I personally take, I mean, this is the best answer that I can give you. The approach that I personally take as a sociolegal scholar is the one that was sketched very, very nicely by Pierre Bourdieu, the sociologist, who didn't write about law much, but he has this wonderful, wonderful paper called The Force of Law. Everyone was writing papers called The Force of Law at one point, but he has a wonderful paper which he says, look, I mean, there are two fundamentally different approaches to understanding law, two fundamentally different approaches to legal theory. One is instrumentalism and one is formalism. And instrumentalism says, look, law is an instrument, it's a tool. It's a tool with which you can do any number of other things, and it has no constraining force. And there's no sense in which the doctrinal architecture, the bread and butter rules and principles and norms and standards of law, international law, constrain your choices or constrain what you're able to do with them. The other approach is formalism in the sense that law constitutes an internally coherent and immanently rational system or order. So, if you're familiar with the work of Hans Kelsen, I mean, you have a very, very good example of just that kind of thinking there. Both approaches are inadequate. They've both sort of got certain things right, but both approaches are fundamentally inadequate. The formalist absolutizes law into this, elevates law into this sphere of, the internally coherent system that really has nothing to say and no intrinsic connection with anything else, politics, economics, and so on. And the other one the instrumentalist simply reduces law to politics, economics, etc., thereby missing all of the attributes that really characterize or mark out law as law in the first place. What we need to do, and I agree with Bourdieu fully here, what we need to do is really develop a third way, right? And the only way you can do that is to understand law as a field. As a social field, one among other social fields. It has its distinct defining attributes. It has its argumentative tropes, its recurring patterns of reasoning and argumentation. Right? You have to master those. It has a distinct structure. But none of this is divorced from politics and economics. Right? It's all rooted in, or at least very, very closely tied to, what we would characterize as politics and economics and so on. So Koskinen is trying to say something very similar to this, right? It's a language. It's a language which, like any other language, has very, very strong connections to politics, economics, and so on and so forth. In order to learn the language of law, like any other language, you have to actually learn its grammar, its syntax, its vocabulary, and so on and so forth. But you can't lose sight of the fact that this is actually a fundamentally political and political-economic project as well. So I don't have a catch-all definition, but that's the best I can do.